Liberty Nation with Tim Donner.
And now we have reached the portion of Liberty Nation Radio which we entitle Talkin Liberty, which is, to most or all of you, self-explanatory. It's when we reintroduce our regular contributor, constitutional lawyer, LibertyNation.com legal affairs editor, and the man we like to call the guardian of individual liberty, Scott David Cosenza. Hello, Scott.
What a pleasure, Tim.
I wanted an uplifting opening
right.
because I'm not sure
the
that what we're going to talk
or
about,
not, depending on your point of view.
What we're going to talk
Sure.
about after that is not necessarily so good. But let's call it what it is. It's high season for the Supreme Court, and not just for legal eagles like yourself, but those of us who are interested observers, as I like to call myself, hopefully informed observer. And SCOTUS has added gay and trans individuals to Title IX of the Civil Rights Act of 1964. This is a significant ruling, but one I would contend is entirely unsurprising.
Well, I think that the surprising feature about it is the rationale given and the author of the majority opinion, or the court's opinion,
Yes.
Tim.
Mm-hmm.
And this was a decision authored by Justice Gorsuch, a Trump appointee. And the rationale for the ruling is that the plain language of the law requires the inclusion of these people as protectees under the law. The law says that you're not allowed to discriminate on the basis of sex in hiring or firing. And what Justice Gorsuch's opinion says is the very nature of hiring or firing somebody because they are gay or trans necessitates that you've taken sex into account in that ruling. And I think it's a positive ruling for limited government advocates on the basis of that rationale. Justice Gorsuch hasn't said, and the court, by the majority opinion, by those justices who've signed on, not just, Tim, to the result in the case, but the reasoning in the case, is that if Congress wants to exclude these classifications, they can pass a new law to do so. Now, that's
let the legislature deal with it.
Practically speaking,
Yes.
that's not going to happen,
Right.
I can tell you. But it is the appropriate posture, I think, for a Supreme Court justice to take, which is we're not going to massage the law to fit into what we think you meant or should mean or would like it to mean. We've got the words on the page, and if they indicate a certain response from us, that's the response you're going to get. Now, I will hasten to add that Justice Thomas, among the other dissenters, basically thought that this was legislating from the bench on the part of their colleagues.
The problem is that the left is always a reliable vote for the progressive agenda. They never, ever break from it. And yet, on the right, we say you need to follow the law, but if you follow the law, you're going to get results you don't want. So it's a results-based leftist bloc versus a law-based, mostly, conservative bloc, as we lay it out that way.
I don't have the site for where he said it, but I recall that Clarence Thomas, I think, once talked about the way of judging for first you don't decide who should win, and then backfill the opinion to get to that point. You go through you start with the Constitution, presumably, and then you decide. And it seems to me, Tim, that the conservative justices do seem to be more interested in intellectual honesty there rather than results-oriented jurisprudence.
I think it's also clear through this decision and a couple of others that John Roberts, the Chief Justice, is headed for David Souterville in the minds of conservatives because he has become, he has a judicial philosophy which is hard to discern.
It seems hard to discern, and also we now have, because of the various statements back and forth over the past year, perhaps some grudge between he and the President of the United States. Mm-hmm. We have the DACA rescission, which is to say that the Supreme Court has ruled that the Trump administration acted in contravention of the law when they rescinded the DACA program put into place by Barack Obama. And that's a big loss for the Trump administration. And the way they did it, I presume that that Chief Justice Roberts has an ego as well, as do so many.
Really?
Right? And perhaps that
Breaking news.
would weigh part of his decision to vote with the liberals in ruling DACA was not legal.
And I think the problem that conservatives or free marketers or libertarians or that group of individuals have with the court is that there's judicial activism on one side and not the other. This is what I'm saying. And what the court didn't do or refused to do this week is equally troubling to defenders of the Second Amendment. There were, 10 cases that they could have heard, refused every one of them.
So the problem, Tim, is that the court articulated a clear standard that the Second Amendment right to keep and bear arms is a fundamental right. You got to focus in on that fundamental word. And the reason why is because the level of scrutiny that the justices are supposed to apply to laws that infringe on rights is different when it's a fundamental right, okay? You're wearing a plaid shirt today, and the right to wear a plaid shirt, you do have the right to wear a plaid shirt, but it's not a fundamental right. Yeah. Some fundamental rights are not explicitly stated in the Constitution, but yet they are held as fundamental. So you might think of discrimination based on race, for instance, or sex, that is part of the Civil Rights Act. Those things can be fundamental and not specifically listed. The Second Amendment is both. It's listed in the Second Amendment, and the Heller case says that it's a fundamental right. And the McDonald case applies that to the states. Full stop, Tim. What we have, though, is many jurisdictions around the country seem to have enacted laws which infringe on that right. And the Supreme Court should grant those cases to hear them and establish in the legacy of their own jurisprudence what those rights mean. They refuse to do so, we presume, because they don't want to give a win to the pro-gun side, which is to say we assume that the lefties on the court don't want to take this case because of what it might mean.
But there was no pushback from the constitutional bloc either.
We don't know what is in the minds of all the justices. The only justice, Tim, that actually wrote about the decision not to take the case was Justice Thomas, who wrote extensively about why the court should take this case and that they were basically in dereliction of their duty not to.
I think this also shows about Justice Gorsuch. Part of the reason that you've admired him is because he has real libertarian chops. Unlike a lot of the more establishment conservatives on the court, most of the rest of them, probably except for Thomas, right, who were establishment type judges who defend the establishment, deferential to the state.
I think that's right, yes.
But Gorsuch is not that way, right? And you identified that early, and for the most part, the right, as it's broadly defined, has been down with Neil Gorsuch. But now, I don't know that they like that independence, rule of law thing quite so much.
I would hope that they would take the time to read the court's opinion in the case, Tim, because, again, it is the justification that he uses is a conservative justification. And I think it's one that is hopeful for Justice Gorsuch's jurisprudence if you believe that fidelity to the Constitution is the most important thing.
Now, we had another issue that came up this week and has been the subject of fierce debate, and that is tasers, because of this new incident in Atlanta where the taser was stolen from the cops. The guy ran away, turned around, let it go twice, fired the taser twice, and then was gunned down. The guy, the cop is being 11 counts. He could face the death penalty. Let's talk about that first, because you often say that it's a major problem when in these high-profile cases the defendant is overcharged because it will wind up with an exoneration which will just set the radicals loose in the streets.
The Rayshard Brooks shooting certainly, Tim, bears the stamp of overcharging. The police officer in that case has been charged with how many attempted murders and assaults? I lost count while I was watching the press conference, and I happen to know that police academies across the country that use tasers all teach. In fact, they're all required by their legal agreements with taser. In other words, they're not going to be able to use tasers unless they agree to the following training protocols, so that they're consistent throughout departments. And part of that training says that if a person has your taser and goes to use it against you, the indication there is for you to use up to and including deadly force to stop it from happening and recover it.
Doesn't this mean that he's likely not going to be found guilty of felonious murder?
It's hard for me to see how he would be, with the exception of I heard that reported at the press conference that one of the police officers stood on the man's shoulders afterwards, another one kicked him in the head. Those seem to be assaults that are irrelevant to an attempted murder, which has to do with the shooting. There seems to be a misconception in the public that police are only allowed to use deadly force if they're combating deadly force. That's not true. Every police officer and member of the public is allowed to use deadly force simply to stop serious bodily harm. So even a broken arm, if you were risking that, or the serious bodily harm that could come from being tased while running, like the police officer faced.
Hey, this may have been our best Talkin Liberty ever.
Okay, great.
Thank you, Scott.
Thanks.